commissioner with another 6 years.
DOPT, have you seen that? DOPT, have you seen?
May just try to explain. If you read it so literally, an election commissioner will have 6 years. And then, even as a chief election commissioner, he should also have 6 years.
Absolutely.
Therefore, somebody will have a 20-year tenure in the election commission.
You are saying that somebody on the supposition that you have to necessarily appoint the chief election commissioner by way of promotion from the post of.
But that's how the law stands today.
That's how
the law. If you want to disrupt that, then it's a different debate.
law.
Where
Where do you say that is a law?
That's
Where is the law?
the
say that
promotion of an election chief after the whole controversy in TN station,
No.
right? Thereafter, now therefore, if you have to enter into that debate, I'm only wondering: are we entering into a debate about interpretation of Rule 4, Section 4 for this purpose?
Because it stares at our faces in so many words. You say that the election commissioner will be appointed for a term of 6 years. You say separately that chief election commissioner will have a term of 6 years. What does it mean? That chief election commissioner must be somebody who is to hold ordinarily, he must be holding the office for 6 years. The proviso carves out the exception. In case he becomes 65 in the course of the term of 6 years, he will vacate office the moment it's fine. But what you are doing, you have been doing this for a long time. You are not blaming this government or that government.
No,
this is your understanding.
Yes.
That you can have a situation where you have election commissioners, make it a feeder category, make it promotion. So whether you know for sure that he's never going to have 6 years, let it be that way. Contrary to the section.
No. Perhaps not. Because
last thing, and I am done. Only one last question, and we want to know, Attorney General, what we wanted to know is, we would like to see.
Kindly see the dynamics of it.
Kindly enlighten us.
I'm trying.
Kindly enlighten
Yes.
as to how the law minister picks up these 4 names.
Now,
What is the criteria?
there are 3 factors. Now, anyway, somebody will retire at the age of 65 years.
Pardon?
Election commissioner, chief election commissioner, that's 65 years, right? The cap is there. So, keeping that in mind, then assuming for a minute that this practice or a convention of promoting an election commissioner, chief election commissioner is not in terms of any law, but it's just a convention or a practice, then we will have somebody who will attain the age of 65 years, but we must necessarily have a 6-year period of the election commissioner.
That's what.
That's right. Therefore, when we read whether we can have, see, the question is not
Parliament. That's the will of the people.
right. That is right. But then that leaves a certain amount of working of this. Namely, can I have somebody with a certain amount of suitability, experience, etc., who would not hit the mark of 65 years, but still will have 6 years tenure?
Absolutely.
That choice is a choice depending upon the officers entering the civil service.
We are telling
Therefore, are we going to?
We are telling you, if you say that,
Yes.
for 40 years,
Yes.
from 1950 onwards till 1989,
Yes.
we were having chief election commissioners being directly appointed as chief election commissioners.
That's true. That's before the
So it is
all that.
No, we are saying that it is not as if we are saying something because we've got the weight of experience.
No,
40 years, we were having chief election commissioners
No, are we-
being directly appointed from the
No,
civil service.
right.
No difficulty.
Yes.
Civil servants, because you said right from the rank of a district collector, they act as presiding officers. So there is absolutely, it is perfectly justified if you were to appoint directly. And that will be in tune with the parliamentary intention that when you appoint somebody for a term as a chief election commissioner, the term should ordinarily last for 6 years. We are only pointing out what is there empirically. What
No,
I
great, understand. But then, unless we know that the pool from which you really generate the whole system is amenable to all these questions. Therefore, a civil service, you have people entering a particular batch, 83 batch, retiring earlier, 84 batch, retiring later, things like that. Therefore, the whole dynamics of a person's in the pool. So you look into it, and I said, who will have 6 years, who will not have 6 years, all that is taken into consideration. I hope the executive is just not. I mean, I want to clear this thing anyway. The executive, are they really playing with it because they want to play with it? I think the answer is no. I must say emphatically the answer is no. With the amount of insights I've looked into the files for the past 10-15 years, I looked into them.
But then how did this 4 names be?
That's what I'm saying.
Yeah, we are asking what is the
The persons, for instance, the previous election commissioner's appointment. Then thereafter, who are the persons in the next batch? So the batch-wise seniority people are picked up. And therefore, in order to see somebody with a retired officer also a convention, I told your lordships. Therefore,
Attorney, you're not requesting. You might be able to find out of the 4 names to give us a justification. We are not on that point.
yeah,
We are requesting you to place before us how the Ministry of Law and Justice has on their database selected by whatever the mechanism filtering down these 4 names.
there are 2
You
criteria.
may say with the names before us and we can find out reasonable justifications both
My
sides.
earlier note which I gave yesterday, clarifying that, you'll also see how it really
Attorney, you understood what we want from you.
No, no,
You are
I'm
not answering that.
No. I am not keeping away any.
We are requesting you.
I am not keeping
we
away
just want our satisfaction.
I am not keeping away any answer because I have nothing to hide.
We are requesting you. We just wanted to know from you.
Yes,
Let us know.
that's what I am trying to point out.
You want to justify after the selections?
No. I am trying to point out. Your last question is, this panel, 4 persons, how do they really come in? Yes, the answer is very simple. On the basis, suppose you want to have a panel of people, even retired, serving, what is their year-wise batch, what will be the age of retirement, all that comes into the reckoning of a panel of shortlisting. A shortlisting is done on that basis. If a shortlisting is done on the basis, thereaafter,
Now tell us one thing. What way the aid and advice of Council of Ministers?
suppose people kindly look at this, they have belonged to the 1983 batch, 84 batch.
Where is the aid and advice of Council of Ministers gone?
Let us not get into that question today for the time being.
Why?
We are not on that question. If that question is answered, we have a larger debate again, we can open up the debate, no problem at all. We are not on that question at all. If you start doubting, I have with a great amount of reservations, if you have to start doubting every small step taken in the process of appointment in such important position, look at the implications for the integrity and the independence of the institution in outside. Now, what are we talking about?
Attorney General.
Therefore, a little dent, a small dent somewhere will make a lot of difference.
That's right. Please, Attorney General, kindly come to the, you've got a page, I think it's A8, which you have marked for.
Page number
A8, you have put it as A8.
A8.
Yes,
That is document A8.
yes.
Yes.
We're not taking the name of the person.
Yes.
We don't want to, because that's not relevant for us. Kindly see the date of birth.
Yes.
What's the date of birth? 34/1960.
Yes.
34/1960.
Yes.
In 2022, what will be your age? 62 years.
She has retired on 30th of July 2020.
Our question is going to be something different. 34/1960, she's 62 years. Even for a term of election commissioner, she could not complete a term of 6 years.
That's right.
Give an own chief election commissioner, she could never become. Now we come to A9. We are not again taking the name.
Yes.
The date of birth is 5/5/1960.
Correct.
That person is also 62 years.
Yes.
Correct? Okay, that is also same. Next
Yes.
man, 8/10. We are not taking the name. Date of birth is 28/9/1960.
Yes.
Correct? So is it the law that you will appoint only retired bureaucrats? Is it that law which you are following?
No. That's
If-
why.
if
That
it
is why.
So our
yeah.
question is something
Yeah.
different. Our question is, you would expect that when you exercise your power, in other words, accepting all that you say, that you would act in such a way that you will also comply with the statutory injunction. Which means that you are ordinarily supposed to pick up persons who would have a 6-year term, either as election commissioner or as chief election commissioner. We'll accept all what you say, but even then, the names you have picked up are such that they would not even have the ordinary term as election commissioner. Next question is the
Yes.
most important question according to us, which is this. By narrowing the scope of the panel to these 4 names, are you not shutting out those names who are sufficiently senior? Bureaucrats, we are going by your theory, the bureaucrats are the ones who are the best. So you have the 20-year rule in Pakistan for just having that as a yardstick. But we will have the same yardstick. Somebody becomes an IAS officer by the age of say 28 to 30, ordinarily. So by say, if you have the yardstick of 20 years experience, by 50, 52, 53, be fairly senior officer. Now, why do you select people? Why do you have a panel which will force you to appoint from that panel only those persons who will have, you will never have the term. We okay about that. We have conveyed what we are having.
No, I understand that.
See, if you put somebody at 62, if you have to select any of these persons, then you cannot appoint them. And then you say, because this particular person who is chosen is the youngest and he's have a long term. So what happens to all those others who would have been in the same category as the person?
There is none else.
Nobody.
That's a problem. That's the point I want to make. Batch wise, date of birth is one thing.
Yeah.
But a person earlier in age or later in age could have entered service at a different point of time. Therefore, the year, the batch wise cadre, all that is taken into consideration. So if somebody belongs to 83 batch, 84 batch, 85 batch, therefore you go by batch wise.
That's right.
Somebody could have been senior in a later age. So all those dynamics comes in. Therefore, how do I draw a line between the pool of officers who should be picked up?
So
how do I really draw?
So why? So the point is that you have to also violate the law. If your theory is accepted, that you are hell bent on seeing that nobody will ever have a term of 6 years as election commissioner or as chief.
No, I don't think that intention could be imputed. I don't think with great amount of respect.
No,
with a great amount of respect.
What you're saying, and you know that. Still waiting to see. You're saying that the council of Balbir Singh was saying that if you put in place this, not that this is just we are all considering various possibilities.
Yes.
You never get the impression that
yes.
made up our mind in any manner. When we ask questions, it should not give the
no. Certainly, I'm bound to answer all your
impression. Nobody.
I mean,
It's just a debate that we should be having.
It's a debate which I think all of us must play a due role. And I certainly understand what my role is.
We are clearing the air that there should not be no impression in anybody's mind that we are against you or their favor or anything of the kind.
Certainly not. I will never get that impression.
So what we wanted to know was Balbir Singh was heard arguing that if the suggestion of the petitioners is accepted, you will have what's called a pure recommendatory body in the form of this collegium of the Prime Minister, the leader of the opposition, and the Chief Justice. Now we have the cabinet system, Article 73, 74, 77, rules of business. Therefore, once the collegium recommends, will it not get stuck in the proceedings of the Council of Ministers because it has to pass through the Council of Ministers recommendation. So there, we want to just clarify because it was pointed out last time that under the rules of business, you have framed actually the matter relating to appointment of the Chief Election Commissioner, the Election Commissioner, we only go to the Prime Minister under the rules of business. We want just confirmation about that. That's a procedure.
That's a procedure.
He doesn't have to go to the cabinet. We wanted to know that.
That's a procedure.
No, Balbir was saying it has to go to the cabinet.
He was because there are other appointments, the ACC appointment.
That's right.
ACC appointment go through a cabinet secretariat.
So
but the level of responsibility and accountability, there can't be a difference.
Absolutely.
Right. And then there are different categories of appointments. That's right. One last clarification. You kindly, I want to lost attention to Section 6 of the Act.
Sorry?
Because there is a question about voluntary retirement and all that. I told you logically that the central government or the Prime Minister's office has nothing to do with somebody relieving somebody from his cadre. They have nothing to do with that.
Incorporated the details, and in third tab, information sought for is reflected.
Okay. You get that one?
Pardon?
Can you take the notes? Whatever is there.
Take your losses, just.
Brother. What are you saying? Attorney General,
Your Lordship.
you said that there are no other officers who are, are not going to retire and things like that. We'll just give it from Punjab itself. They're just taking a name. Or we'll not take the name, but we'll give the date of birth. The date of birth is shown as 1/9/10/1973. She's a level 17 of in the pay matrix, same as the other officer. She's a chief special. We'll take only the name. Special Chief Secretary to government. We are not going to name the department. She is 1963 born. So your age there, that there are, you want to see this? We just.
I know.
That 88 batch officer. Now, this gentleman is an 85 batch officer. If you go state-wise to the other states, you'll find there are 85 batch officers who have born after December 62.
Yes.
The first man in Tamil Nadu, for example, the first person in Maharashtra, for example, the first person in Madhya Pradesh, but they're not.
No,
We are not.
Yes.
So sorry.
We are not examining the issue as to who is it.
Correct.
We are on the procedure.
Exactly.
So therefore, my elected logic is have a panel of 100 names, right? Pick up among them. Even then somebody will say, please don't get
We are
it.
not saying that.
What-
We
what-
will intentionally or deliberately not trying to understand what we're saying.
What you are saying is.
Yes.
We check that.
Yes.
We thought that, there's nobody, you said there is nobody, who is.
No. The question is, if you have to have an unwieldy pool, right? Then the question of first selection, second screening, third screening, how do we really go into the screening process? So every time somebody is screened out, my elections will come and say, look at what have you done? Are you therefore getting into a question?
What is the criteria which a law minister employed?
For
We'd
if-
like to know,
if-
you
if
picked
in
up
the-
4 names.
Then it should be 4 instead of 4, 8, 10, 12, 20.
8, 10.
No, I'm
Let
a
us hope
little,
we are not
Yes.
sort of
I'm so sorry.
trivializing our
And so-
worry. Our worry is basically purely, legal. What you're saying is when an executive body is acting,
Yes.
power, constitution, or it's an executive power act. Basically, it's a power which is being given to a point, finally, under the constitutional provision. So you have the Wednesbury principle, but we are not doing that judicial review as such, but we are on the whether we need to step in. Very, very important question that you said, we said with a lot of difficulty. So we were a little mystified. How would you pick up from a database, which you say there is, of officers, name, and we pointed out 3 out of them could not possibly, fulfill the requirement at all. There are others, it is pointed out. And it's from the list which you asked us to see, we found there are others.
Let's rectify it.
So then how do you answer that?
No, those persons who would not, look. We tried to explain.
You want to say something? Sorry.
Okay, I want you lot to look at also section 6. Before I come to section 6 of the Act. Now, batch is one important criteria.
Pardon?
The batch to which a person belongs is one criteria. 83 batch, 84 batch, 86 batch. That batch is the criteria. The date of birth will be a criteria only for to find out whether somebody would have a reasonable tenure before entering 65 years. The third is among batch seniority. So would be senior among them. So these are 3 or 4 factors which come in. Now, therefore, I ask myself a question. Having regard to the practice which has prevailed over a period of time, it is comfortable. If it's comfortable for a zone of consideration with small number of people and who are found to be otherwise, and after all, the government knows, depending upon the service profile of a person. Now, to go beyond the service profile and to now say you are having a very short panel, and the short panel has been decidedly designed to pick up somebody who will fill up your bill.
Yes.
To reach that conclusion, I think would be very, very difficult. The court will now put itself into the decision-making body or a thought of a person who is otherwise held to be accountable for the very important decision somebody is making.
We only ask you one question.
Your Lordship.
We'll give as the last chance, we'll ask, I'll
Yes.
stop asking. Was there any criteria for the law minister to pick out these 4 names?
That's
Just
what I'm
tell us
trying
one
to explain.
criteria.
That's what I'm trying to explain, Your Lordship.
One criteria.
You see, initially it is a question of batches. the batch is coming. So among the batch people, will somebody have a longer tenure? That's another consideration. If that consideration is wrong, then I think no other consideration can help us. It is therefore a question of who will fill up as nearly as possible the requirements of the law.
So you went by batch.
Yes, batch is taken into consideration.
What batch? means?
Kindly turn to the same page.
84 batch you are saying.
Kindly turn to page 4.
So therefore you are saying that only persons who are on the verge of retirement should be appointed.
Yes, that's what I'm trying to point
No,
out.
ultimately you are saying that we have to put.
Batch is one criteria. Among batches, who is senior? Among them, who is probably other profile and suitability. Therefore, 1, 2, 3, 4, 5. So these criteria, then somebody will score out 1, somebody may score out 2.
So
then how do we have a selection process?
What you're saying is therefore that persons who are on the verge of retirement,
Yes.
who will definitely not get the term of 6 years either as an election commissioner or as a chief
Correct.
election commissioner, are carefully picked and chosen.
So therefore, that's why I'm trying for in a given
Is there a rational criteria?
in a given situation,
You
you
are
may have,
violating the law. You are violating Section 6. We are telling you openly.
no, your lordships are right.
They are
Therefore,
expected to get 6 years.
no, but I only want to ask this question: how do we really come and honor this 6 years criteria? I said either a chief election commissioner will not be any longer promoted from election commissioner. We must do away with that convention or a practice. Then what happens? Somebody comes to the election commissioner, he will have 6 years tenure, walk out of the election commission after 6 years of tenure. Then we have to find out a chief election commissioner who will be appointed chief election commissioner. Therefore, we get into an imbroglio prior to TN session case. Why do we get into an imbroglio?
Mr. Attorney,
Yes.
we are completely with you. Whatever the mechanism which is available at your command, you adopted it. Nothing
Yeah.
wrong in it.
Yeah.
We are not supposed to question, and we are not questioning. Our and worry, anxiety is only one, which is not this. What is mode you adopted? If you see 85 batch or 83 batch, whatever the batch is, and you go to the database, you will find the age factor, the batch factor, the profile factor of the persons of a particular batch. You will find large number of officers. Our worry is not this to whom you select. It's your choice. It's completely within your domain. You have to do it.
Yes.
Completely. We are not on the question. If 85 batch or 83 batch is the denominator for the purpose of filtering the candidates for making a final call, fairly good.
Right.
But you said we want to keep in mind the tenure of the person to complete 6 years nearby, looking to the age factor and
Yes.
his entry level to election commission.
Yes.
Because according to you, election commission, and that very person later on appointed to chief election. Fairly good.
Gotcha, sir.
You want a person must have experience of election commission
Right.
before he is given a charge
Right.
of the post to help other affairs. Nothing wrong.
Right.
Absolutely. We don't have anything to say. But if you are selecting a person of 85 batch
Yeah.
with an age factor of 62, 61, 63, whatever it is, your choice. But you will find if you go to the database, because you are downloaded from database, and this is a filter from database. If you go to the database, you will find the combination of date of birth, the combination of
Sure.
the batch,
Batch, seniority.
may be almost similar. And you will find, suppose, 20 people
Yeah, lordship.
of the age factor and the batch factor from various state cadres.
Right.
Okay. Our request, what we are following to you,
Your lordship, please.
we are on a different point. We want to know from you what is the mechanism which the Department of Law and Justice adopted to filter down and select 185 batch officer of this age. This is our question to you. I think we made ourselves clear to you. If you have 20 officers,
Yeah.
25 officers of 85 batch with almost the same age factor available on the database, so you can select. Absolutely, it's your domain. But we just want to know from you, what is the mechanism you adopted to filter down and select one officer of this age factor with this batch as the only officer under the
Very well.
filtering guide?
There is only two ways of looking to it. The one way is, I want somebody, therefore I'm picking him up. Regardless, ignoring all other factors. Ignoring all other factors, I want somebody, I'm picking him up. That's one way. Then the other way is no. I have a certain comfort zone in not getting into an unwieldy panel. then I may have to find out how to weigh the relative profile, suitability, experience of a large number of people. How do I really weigh them? It's a very difficult weighing experience. So the larger the field, then of course, the large.
You have to do it on one day.
Yeah.
You have to do it on one day, on 1811.
Yeah.
Everything is done.
No, these are all factors which
No,
in a given
the files.
Yeah. I only want to.
One day.
I only yes.
1811.
Can I just have 2 more minutes?
Sorry?
Can I have a kindly turn to section 6 of the Act?
Certainly.
91.
I just want to point out that there are some disquieting features which are thought to be present to them. And I want to dispel all that impression. And I thought there's nothing confidential about this document. We have shared it with them.
You've been very fair.
That's the best way of instilling. That's the best way of instilling and enhancing the quality of debate in the court, and to ensure that the independence is also ensured in that. And therefore, that's
Section 9.
section 6,
That's in the volume
page
1.
153 of the compilation,
Volume 1.
volume 1.
151, page 151.
Before I read that section, so any person, this gentleman is otherwise superannuating on 31st of December. And regardless of the age of superannuation, if the government finds among other persons the profile, I think you would better serve and you can pick him up. So the government picks him up. So the question whether he will retire or not may not weigh with the government. And if, for the purpose of comfort and convenience, that I'm going to retire anyway in 31st of December, let me seek voluntary retirement. He seeks voluntary retirement from a cadre on which central government has no control whatsoever. And they respond to the voluntary retirement request and is given voluntary retirement. That will not make a difference whatsoever for the government to take into account whether his profile is important, not a voluntary retirement question.
That's correct.
So kindly turn to section 6. A person who immediately before the date of assuming office as the chief election commissioner or an election commissioner was in service of government, he shall be deemed to have retired from service on the date on which he enters upon office as a chief election commissioner or an election commissioner.
That's for the purpose of pension.
That is true. That is true. Therefore,
what is the question? We are not concerned with the
no,
question of pension.
because that small grey area where it says, oh, he's taken voluntary retirement only for the purpose of a nudging from somebody, getting voluntary retirement, now make him election. All that is
Just read the most crucial provision.
yeah.
When you're talking about this act is framed in accordance with 324(5).
Yes.
Conditions of service.
Election.
Election.
Right.
The term of an election commissioner will certainly form part of the terms and conditions contemplated. So in that term is very important. And you say the chief election commissioner or an election commissioner shall hold office for a term of 6 years from the date on which he assumes his office. Then you have this proviso which you incorporated in 93. After 91 Act came, you made it in 93 by an ordinance in
That's
93,
right.
and
That's
that came
right.
in by an act. So, do we have a situation where the proviso will actually overwhelm the main provision every time? The proviso becomes the rule. See, when you're interpreting this as, you have to understand what the parliament.
That the tail will not wag.
So we get here a situation where the rule says he shall have, it is not may something like that, he shall have, it's imperative. Both as election commissioner and as chief election commissioner, because the separate appointment orders will be there. When even if you promote somebody, you can produce that, we have any doubt.
Exactly, it's well received. I'm not sure.
So he will have term of 6 years. We know, everybody knows that he will never have it.
No, this question certainly come into our mind. We had discussions where the only possible answer is yes, it happens like that, but there is no design. There is no design.
It does not happen like that.
No.
What you're saying?
No, it's very difficult unless I have a 40, 50 years of profiles and show how it has happened, why it has not happened, how the choice has been made. That exercise, maybe.
The point is, Attorney
Yeah.
General, what really binds us, guides us is the will of the people speaking through Parliament, the law. The law is a clear guidance. The law says, shall have 6 years, shall have 6 years. So ordinarily, your effort should be to see that law is actually observed, not in its breach, but
I can't be in disagreement with it. I'm not even saying anything.
That's all we are saying.
All that I'm trying to say is having looked
Now
into,
the time is up, and let us go.
having looked into that. Therefore, this disquiet that's being taught, I say yes, in my understanding, very humble understanding, the way the system is working, how the convention is working, and how there is nothing in which, I don't think there is a possibility. If the court were to go to the extent of saying there is always a quid pro quo in the appointment, I think that court is not.
We are not.
That's right.
Absolutely not.
Correct.
We don't know from where you gather it. We never thought it. And we never think it. Sorry. We are only on the question of the procedure. Absolutely. Don't take this impression.
We are also not saying it.
Yes.
No, but what's the suggestion?
No.
You are saying there's a process which is
We are
flawed.
not.
The process
We are
which
not
is
on
flawed.
this at all.
Yes.
Sorry, we are not on this issue.
Yes.
Absolutely not.
You see, yesterday we requested for the file. Today you have produced it. So to that extent, we say good thing has been done. All right. Now you are trying to justify on the query of the court that the law minister has shortlisted 4 persons, 4 names from a large database. We try to understand what is the basis for shortlisting these 4 persons. We are still struggling with the logic and the reason, right? Talk about the age, you are giving 65 years. But perhaps there will be many more officers who fit in the profile that you are trying to suggest the court was the basis for the law ministry's shortlisting these 4 names out of the data of maybe 100 people, that age category. Now, age category is relevant because you have a particular tenure, you have a particular age related to the office, 65 years. So it's relevant. You may be right in saying that the age is the criteria on the basis of which we have shortlisted these 4. But if we find, and of course, we have also said that we are not testing the appointment of this particular person. We are basically in this process.
I quite see that.
Testing
Very
the
important
process.
I
Testing the process.
correct.
So what is the process through which you make the appointment of election commission?
Yes.
If we are testing the process, and if you say that age is a factor, and it's a factor, it's a relevant factor, but if we find that besides these 4, there are 40 others who also fit into the same age factor,
Correct.
then why 4? Why not the other 36? This is the question that we are
Certainly,
trying to
it's a
pose.
well important question.
And one thing, we have talked about the silence of the Constitution, just to lighten the mood a bit, just to lighten the mood of the bit.
Your Lordship, please.
You have given 8 points in your note. Attorney General's note contains 8 points.
Yes.
If there was,
about something else.
yeah, the 9th note is missing, and that could have been the Attorney General saying that election process is all about numbers, and the man who has got a gold medal in mathematics, we have shortlisted him. That note is missing.
I didn't want to put myself in the place of those who have taken the decisions. Just one small concluding. This question will certainly keep coming. Why 4? Why not 5? Why not 10? Therefore, any number of persons who will be placed on the equal footing on an outsider's point of view. When I say outsider, from an external agency. The internal agency now knows how wide we can have a selection band. How wide it can be. The more it's wider, I repeat, as narrow or wide, the question of discretion will always be questioned. Every third seniority of appointment matter from the highest to the lowest level, including judges' appointment before this court.
That's why we thought that why the rules have so far not been framed when the legislature and the constitution.
That's an important question.
If the rules would have been there, the mechanism
Even
process
then-
would have been
even-
very filtered.
Even then, your lordship knows, after rules have been framed, don't we have seniority disputes in the country for the past 50 years?
That's a different thing. You're right.
Seniority,
So you want to
seniority
say
in the
that why should
context
we-
of High Court employees.
You want to say that why should we have a rule that
No,
disputes
no,
will
I'm not
remain
saying
there?
that. I'm not saying that.
Avoid all rules and go ahead.
Seniority in the context
Ultimately,
of,
this court will take a call and decide.
no, please don't misunderstand me like that. I'm not saying that.
Rules are framed. We know it. Every time this court is intervening and the seniority rules are always breached. But still,
Let us look at, that's why yesterday I think I am taking the lordship's time because a very important sharing of thoughts and ideas, and it's going to certainly enhance the quality of decision-making process. I'm very clear about that. But the certain institutions and certain processes probably are best left to certain informality, and when that informality brings about a confidence, then there is no difficulty at all. But whenever on a given occasion, that informality breaches that confidence level, the court will always look into that. But for that purpose, in a given case, a certain doubt has arisen in the mind of the court, then will the court go to the extent saying, I think we will have to now look at the informality. We don't know whether we can trust it, and therefore we'll try to tighten it up.
All right. Thank you.
So that would be a little closer to keeping that, play in the joint. But after all, we're not looking at appointments at a very ordinary level, at a level where other considerations may or may not come. But on one last thing. This, you Lordship put me a question, it happened in May. What happened in May? Many things are, this very highly confidential thing. Informally decisions take place. When do we do it? How do you do it? Therefore, nothing is kept on black and white. It's not like an ordinary note sheet in any other circumstance.
if the vacancy was available to you on 15th of May, then what was that emergency
Let's go.
came across?
Let me tell you, Lord.
One
Very-
fine
very-
morning, you have rolled out the whole system.
Nothing to hide. Nothing to hide.
Yes.
There is nothing to hide at all. Nothing to hide at all. Even before on taking certain things on my shoulders, I must tell you, Lordship, what happened.
Okay.
Because these things come before the court.
Thank you. Thank you.
Even before,
Let us get
I'm
on.
sorry.
Let us get on now.
Yes.
Let them come.
Even before the matter was heard,
Sorry. Yes.
then I was asked whether any impediment in going about the appointment. Was there any problem? Then I thought about the matter. I didn't find there is any injunction or a stay or something like that. There is no reservation on that. And precisely they quoted that there is no reservation going about the appointment. That is how it went ahead. So it took probably about a week's time after I gave my consultation, and then you started moving it. So therefore, the speed part of it was also after my consultation with.
That's all. We are done.
Therefore, I don't think your lordship will see any rat in that. It's very important that certain things take place at a very highly consultative, confidential level, and things are and advice and
Thank you. Thank you.
That's how.
Thank you.
And I thought, keeping in mind the independence of the office of the Attorney General, the advice that I give must also carry weight and confidence, and then it should not lead to any what I call even remotely a remote link or use for anything out of the blue. That's all I want to tell you.
Thank you.
On a matter of fact, my lord, there are 160 officers from the 1985 batch, IAS officers from the 1985 batch. And also on a matter of fact, some of those from the same batch are younger who would have a longer tenure. This gentleman will have a tenure of 5 years. The others would have a tenure of 5.5 or so years, etc. From that batch. Secondly, out of those other 3 people that they have shortlisted, there would be many, many more who are not only senior but younger to them. They have given.
Go through that.
Yes.
You'll be going through all these.
Yes. They have given this chart
Yes.
of the election. Mr. Balbir Singh gave this chart of the election commissioners and their tenure. And if your lordship just sees this chart,
Original file, give it back. You don't need it. Let's just see. Copy which you have given.
so he gave your lordship's chart, which was typed by Mr. Balbir Singh, giving some more information.
That's part of your original file, I think. We are giving it back. You've given us a copy, anyway. We are giving back the original.
Your lordship, please.
You don't need to. You've given us the copies, I think.
Yes.
So yesterday when your lordship asked me this question.
One minute. Huh?
Yes, yes. pointing out a lot of facts.
Yes.
This chart which was given of the election commissioners who have been appointed
Yeah.
in the last many years shows that from Mr. Let's take from this chart which Mr.
That's right.
From 9 to 15, all of them have had tenures of between 2 to 4 years. So this logic which is now being given clearly was not applied earlier. Today we are being told that no, he was selected because he would have a long tenure of over 5 years. But certainly many of the people who were appointed earlier had tenures of less than 3 years. Now, I filed this IA.
Mr. Bhushan, let him complete.
Yes, just one fact. This IA was filed for interim relief in May 2021.
That's why we are aware of that. We are
And
conscious of that.
yes,
We're conscious of
it
that.
was
We
mentioned in my arguments on the
All right.
17th.
Let him conclude.
Yes.
Otherwise, it will not be good. Yeah, 10 minutes is what we had promised you from what 20 minutes you wanted, but we'll give you time.
1.5 hours I've been
We have already spent, but I think
I'll take a little more than 10 minutes.
Yes.
There is something to be said.
Yeah.
Apropos what has just happened. I'm
Just,
grateful.
Gopal, if you can
Yes.
just concentrate on that vacuum.
I'm concentrating on that. I've got something more in addition. It's helpful when we are on our legs at 4 o'clock. It gives us time to rush away and do some additional homework. I'm grateful that we have this Arun Goel appointment file before your Lordship, because until now, it was a vacuum for us. Because we had absolutely no clue what is the procedure, how they shortlist, what they do. What we had transparently available, and which I addressed in the opening arguments, I showed your Lordships the rules of business. Their rules of business says Prime Minister and President. Now we know that there is a convention of Law Minister also. Why Law Minister for the Election Commission? I don't know. I don't know whether he has, as against any other minister, whether he is better positioned. But that's a choice they make. I have no issue. But I'm saying,
Historically, what we know is a law minister has been
perhaps
initiating the process.
perhaps. I will be saying perhaps many times, because we don't know. It's not written. Even now, several questions have been put by this bench to the Learned Attorney General, and there's been no answer about, is it written? Is it there transparently for us to see? Is there a rule? Is there a law? The answer consistently to every one of these questions is a big, fat, resounding no. It's only convention, some ad hoc practice. The second thing that we know, and I'm grateful for the question that fell about how the proviso is serviced over Section 4. The 1991 Act gives a tenure of 6 years. That tenure is provided by Section 4. Till today, they have never, not once, had anybody with 6 years. Not once. Not for Chief Election Commissioner, not for Election Commissioner. Third point, and this is important. In service jurisprudence, we understand cadres. We understand promotional avenues. Here is the other gaping, yawning silence. Election Commission has now become a cadre. There's a promotional avenue between the Election Commissioner and the Chief Election Commissioner. This is strange to me, because the law tells me that the Chief Election Commissioner has a fixed tenure of 6 years. The law tells me that his two companions have fixed tenures of 6 years. The law in the proviso says, by chance, per chance, you happen to be, say, 60 years, 59 years and a few months. Then, when you hit 65, exit. Apparently, they've completely lost sight of the main provision. They've gone only by the proviso. So, and I will show, there's a chart which I have annexed also, which shows at what stage they appoint them as Chief Election Commissioner. Parliament has told the executive, you must ensure they have 6 years. Why 6 years? The reason is, just like it is with tenures of judges and everything else, that there is security of tenure. Security of tenure is independent for independence. You put a man in for 6 months, for 8 months, for 10 months, so that there's a leash. This is not an argument saying malafides. We are not saying malafides. We are saying forget what your intentions are. They might be the noblest. It doesn't seem to us that this institution can be strong, and can be independent if there is a perception of a leash that is being controlled, giving you small tenures, allowing something which Parliament did not allow. Parliament insisted 6-year tenures. Not once have you serviced there. And how do you tell a election commissioner who under the law is told that he has 6 years? How do you curtail it? I ask myself this. It's a tenure which according to them constitution has deferred, Parliament has made a law. It says 6 years. That election commissioner has to get 6 years. You can't tell him after 2.5, we're making you chief election commissioner. You can't. There's no question of curtailing that tenure.
Yeah, put it to him.
Yes. So for me, I just wanted to once again explain what our position is. Unequivocally, because lots of arguments have come from the other side on things which we're not saying. We're not arguing malafides. We are not saying that the only competent people are people outside of the executive. We're not saying that. What are we saying? We're saying two things which are the essence of this constitution. One, independence of the election commission. And I'm inviting your lordships to use that phrase in this judgment when it comes, that the independence of the election commission, whichever way you lordships hold finally, it's important because we are not finding it in this context in any judgments of the court. Dhanova and Session in a different context. But in the larger context of how your lordships came up with the independence of the judiciary, it was there in the directive principle. This is Bose mentioned, yes.
What do you mean by independence?
Independence of the election commission means this, that the chief election commissioner and the election commissioners must be first appointed through a very visible and clear process which has no single dollop of arbitrariness in it. It cannot have.
How do you do that?
By following time-tested methods which your lordships have laid down for many, many institutions. And I'll tell your lordships, if there is one institution where your lordships have had to fill the gap, we have an entire swath of 17 judgments where your lordships have had to fill the gap between the election commission. Not once, 17 times. Because something is not filled up, there is a gap here, we'll say lay down guidelines. Try and follow these procedures. There's something here, fill that up. You have done this. And you've always had to do it mainly with the election commission. Why would you? Your lordship could accept the Attorney General's argument saying, please, hands off, don't touch it. You've touched. You've gone much further than touching. You've actually framed and laid it down. When a law was made which was contrary to your lordship's guidelines, just accepting half of it, you've struck down that law. So you've done this repeatedly with the election commission particularly.
Mr. Shankar,
Yes.
just one thing.
Yes, ma'am.
You've talked about the proviso overriding the
Yes.
main provision.
Yes.
Now, the proviso, I find it came later.
Yes.
93.
Inserted
93.
later.
93.
Now, is there any justification or any explanation why it was inserted, making it 65 years? And also, you are talking about the short tenure argument, keeping them on leash.
Yes.
Now, does it mean that suppose if you have a 6-year fixed tenure provided by the main provision, section 4,
Yes.
then even if you cross 65,
Yeah.
you should be continuing beyond to complete your tenure? Are you trying to
No.
make an argument of
No,
that?
I'm not saying that. The law prohibits me from making that argument unless I challenge the law. I'm not challenging the law. I'm saying when you're doing your empaneling, your encadering, etc.,
At the stage
Your-
of shortlisting, you must
Correct.
keep that into account.
your pool, because just now, I mean, apropos what fell, we went to the same website, which has the entire civil list. It's an ebook, but it's cadre-wise, so it's a little painful rather than batch-wise. So we had to go state by state. When we were looking at the state, we saw many, many people who are secretaries, resident commissioners, very senior positions throughout, who are 86 batch, 87 batch, 88. You can go down to 90. I think this obsession with having people who are so much older, I ask myself that. I mean, you can't have an election commissioner who's 50 years old. Is there some magic line that you have to be?
I can only say that argument coming from Mr. Gopal on the age factor is very appealing.
My hair will speak otherwise. So I'm just saying that definitely should be a conscious necessity that when you start with whatever empaneling process, shortlisting process, look at people who are in their 40s, look at people who are in their early 50s. You hit 60 and then suddenly you start empaneling.
Should we, as judges, determine that?
Not determined.
We are voting people to
No, absolutely. So I'm not saying
Parliament and Assembly for deciding these things.
which has been decided. Which has been decided. I'm grateful for that. Which has been decided. And in section 4, Parliament has applied it. Old, wizened, grey hairs have applied their minds to this and said, of course, now not that old, many of the parliament are very, very young. They've applied their minds to this and said, look, we need to give them 6 years. If Parliament tells you to give 6 years, your empanelment process must start with people who have 6 years to give. It can't start with people who have 5 years to give and say, among those who have 5 years to give, this one man is the youngest after shortlisting 4. You're also absolutely right. They chose.
Already like that. We have already
Yes, I won't belabor that. I won't belabor that. Now, what I will belabor, if your lordship don't mind, and this is directly linked to that vacuum question and to my Lord Justice Rastogi's question to me when your lordship rose yesterday, which is that if that subject to law phrase were not there, would our argument still stand? And I said, yes, it would. And the reason it would is because of this principle of the independence of the Election Commission. It's not a principle that hangs by a thread somewhere. It's very much rooted in the provisions of the Constitution and even further down in that basic feature that is democracy. Your lordships have a passage in that Gujarat special reference which perfectly captures it. The idea is that if you accept, and I think we all accept, that democracy is a foundation on which this nation has been built, and if it's built on that, and we are not, as I heard the Attorney General yesterday, and they of course say that, we are a very young republic. We are not a young republic. We're the 7th oldest republic in the world with a democracy. 7th oldest. That's not very young. 72 years. I don't think we can still keep calling ourselves young beyond a point. 72 years means opportunities have been given to several generations to sort out what the mistakes and problems are, to fill up vacuums if there are vacuums. 30 years were given to them to fill up the vacuum. PNs were sent to them from the Election Commission, from many other commissions. They've chosen not to. Now, if the independence of the Election Commission is crucial to that value that we hold dear, that of democracy, and the functioning of the Election Commission must then be ironclad to ensure not that there is a wrongdoing, but even a perception shouldn't arise. Much like we say of the judiciary. The independence of the judiciary doesn't mean, as was argued yesterday, that we had judges who were questionable before the collegium system came in. Not at all. We had exemplary judges then, we had exemplary judges after that as well. But the question is, the system should be seen to be reasonably independent. And this is not for the executive or for any one body, it's for the people of this country. We are arguing on behalf of the people of this country, on the citizen. Now, on vacuum, there is a note I prepared, and I want your lordships just to see that. Give 5 copies. How specifically with reference to the judiciary. I'm now drawing this parallel, and your lordship will keep this parallel in mind. Independence of the judiciary, your lordship found vacuums, you filled it up. I'm saying independence of, I'm saying independence of the Election Commission. If your lordships find a vacuum, I'll make it good. Please fill it up. Give me one copy. I don't know. I've just taken the extracts. Your lordship familiar with the fact
when it comes to a judge's appointment,
yes,
is it turn on a principle of interpretation?
Interpretation.
Whether you were consultation made it concurrence.
Correct. But
that was
whether
we went far is again
to interpret
rather than
yeah, of course. And your lordships, all I can say is, did your lordships revisit that once, twice, thrice? Your lordships revisited that position. I would, since we had gone into facts, we got into trigger points, let me respond to that directly. In 1980, some of the top lawyers in this country filed petitions before this court. Mr. S.P. Gupta filed, Mr. Iqbal Chagla filed, all part of that same batch. This was a trigger point, if at all could have been argued, saying that after Indira Gandhi brought in the emergency and the Jabalpur bench buckled, ADM Jabalpur bench buckled, that would have been the trigger point for creating a collegium, creating independence. But did the SP Gupta bench do that? They didn't. So this requirement of a trigger point, I don't think is absolutely necessary.
So, no,
it can only add to it.
Swami is, I think, you're referring
Yes.
to that underlying portion.
Yes, I'm showing your lordships these judgments to show where legislative vacuums existed.
We'll just make that note.
Yes,
A note.
I'll just read these. I've just taken these extracts. I don't want to trouble your lordship with the books. In Veeraswamy, on whether Supreme Court and High Court judges can be prosecuted under the Prevention of Corruption Act, I'll read this para. But counsel for the appellant has reservations. He maintained that it would be for the state to come forward with separate enactment for the judges consistent with the constitutional provisions for safeguarding the independence of the judiciary and not for this court to improve upon the defective law. In our opinion, there is no need for a separate legislation for the judges. The act is not basically defective in its application to judiciary. All that is required is to lay down certain guidelines lest the act may be misused. So they're not waiting for trigger points. They're saying lest it be misused.
Yes.
All that is required is to lay down certain guidelines lest the act may be misused. This court, being the ultimate guardian of rights of people and independence of the judiciary, will not deny itself the opportunity to lay down such guidelines. We must never forget that this court is not a court of limited jurisdiction of only dispute settling. Almost from the beginning, this court has been a lawmaker, albeit in Holmes's expression, interstitial lawmaker. Indeed, the court's role today is much more. It is expanding beyond dispute settling and interstitial lawmaking. It is a problem solver in the nebulous areas. In this case, we consider it no mere opportunity. It is a duty. It is our responsibility and duty to apply the existing law in a form more conducive to the independence of the judiciary. Vineet Narayan, I haven't set up the guidelines, your lordship knows what the system is. Vineet Narayan, just this paragraph again. As pointed out at Vishaka, it is the duty of the executive to fill the vacuum by executive orders because its field is coterminous with that of the legislature. And where there is inaction even by the executive, as your lordship has seen, inaction in this case, for whatever reason, the judiciary must step in exercise of its constitutional obligations under the aforesaid provisions to provide a solution till such time as the legislature acts to perform its role by enacting proper legislation to cover the field. Delhi Judicial Service Officers Association, where Article 142 was interpreted.
Well, we have seen it.
I will add a little bit of intonation when I read it out. So, the facts of the instant case demonstrate that a presiding officer of a court may be arrested and humiliated on flimsy and manufactured charges which could affect the administration of justice. In order to avoid any such situation in future, we consider it necessary to lay down guidelines which should be followed in the case of arrest and detention of a judicial officer. Such situation in future. So, no trigger point may come. No person, whatever his rank or designation may be, is above law and he must face the penal consequences of infraction of criminal law. A magistrate, judge, or any other judicial officer is liable to criminal prosecution for an offence like any other citizen. But in view of the paramount necessity of preserving the independence of judiciary and at the same time ensuring that infractions of law are properly investigated, we think that the following guidelines should be issued. Common cause and diagram I'll treat as read. Now, the tests, therefore, are not just limited to the question of there being a trigger. Did something suddenly happen? Something suddenly didn't happen with reference to how the independence of the judiciary was asserted in a series of no trigger points. In the first two cases, it was only on interpretation of the question of concurrence, and the second was with reference to Chief Justice being expanded to mean a collegium of 3 than a collegium of 5. No trigger points. The trigger point may have been the constitutional amendment which was directly challenged, but otherwise no trigger point. The second aspect is, of the 12 categories of unelected constitutional authorities, I'm saying unelected specifically because these are all appointed or this other process, it is only the Election Commission and the National Commission for Scheduled Castes, only these two, where no qualifications have been laid down either in the Constitution or in the law. No eligibility provisions have been laid down. No question regarding this, particularly in the Election Commission situation, if there's promotion, etc. As of right, there is nothing laid down regarding that. The criteria for creating panels, none of this, there's silence on all of this. Pages 1 to 3 of that spiral bound has the entire chart with the columns showing that. Now, maybe the National Commission for Scheduled Castes also there's a vacuum that needs to be filled up. But the only question is the pressing need and the consequence of not filling it up, filling the vacuum. Here you have a very serious consequence of such a vacuum continuing. And if anything, this file has shown your lordship is that there are many questions. I don't think any of us can deny that there are many questions about a decision being taken on one day. And we must ask ourselves, we're always presuming that all these authorities are functioning perfectly in accordance with norms, proper norms of governance. What is the material before them? In one single day, you empanel, you pass on names, biodata. If they have one question or query, they want to find out a little more about somebody, nothing happens. It all gets done in one day. We find lots of dissatisfaction with 23 bills being passed in one day by Parliament. Now we find the executive doing something similar on a single day. We expect for something like the election commissioner of this country that there will be a little bit of deliberation. I don't think that's too much to ask. I don't think any person representing the executive can possibly tell your lordship, no, we want to do it in one day. Impossible. In my view, as far as the constitution is concerned, deference, deliberation, deep thought, questioning. Maybe you want to meet those people, you want to find out what their thoughts are. All that is necessary. For any constitutional position, I'm not only talking about this, I'm saying any constitutional position. There is deliberation, there are interviews, there are many rounds of things. What is this one day business? Have we descended to such chaos that we will appoint somebody as high as the election commissioner in one day? Now, the one vacuum I've mentioned in comparison to the other constitutional authority. Second, I mentioned yesterday, so I'm not going into it again, about how those...
Pardon?
Yes. Yes. My apologies.
Yes, so that,
Yes. No, absolutely. Yes.
So you have made your point there, so that, we understood.
Yes.
Can we close it?
Well, I have some more. I mean, I've spent a considerable time creating this compilation.
You wanted 20 minutes, we have given you.
Just give me 5-6 minutes. I mean,
5 minutes.
These are new facts.
Okay,
You give me 5-6 minutes. I'll finish by 12:30. Your lordship will give me till 12:30. I'll wrap it up. I didn't anticipate that the Attorney General will take this much time today also. So just, your lordship may give me a little bit of time on that.
Yes.
I'm sorry, because the way we had estimated it, we had not anticipated that the Solicitor General would come and make arguments also. I mean, it's unanticipated.
Not beyond 12:30.
Yes, very well.
We start the other case at 12:30.
Very well. Now, if your lordships take my note,
Yes.
I've said that there are two conditions that follow. First page, third note. Condition 1, that the existence of a fundamental norm or basic feature that needs to be secured. Now, once the vacuum exists, it's not absolutely necessary that the court steps in to fill it. The court will step in to fill it. My Lord Justice Rastogi has that note. That 2 pages. 2 pages, yes. So the first condition that has to be filled is that there has to be a value, a fundamental norm, which exists here, at least 2 separate norms. The second is that the existence of the vacuum is having a grave effect on the rights of the public, either directly or indirectly. Lack of independence of the EC gravely affects democracy, such as the EC must be independent, just like the judiciary, like as your lordships have said in Scora. Absent both of these conditions, there may not be a felt need for the judiciary to intervene, as there could be several other vacuums in the constitution which could be left untouched. Other values which have to be applied, institutional integrity, which your lordship laid out in the CVC Thomas's case, an independent appointment mechanism, which your lordships have laid down in Beneath Narayana, a non-arbitrary process after the decision in Triple Talaq, where your lordships have used manifest arbitrariness as a test for laws. It has now been followed in about 22 cases. That test has come to stay. So now your lordships will examine whatever guidelines are being laid down, will ensure that there's no possible elbow room for such arbitrariness. On the right to give 5 copies, on that point, and I think it's important, your lordship might finally settle the law on the right to vote being a constitutional right. There is a very interesting article which I read many years ago, which I've annexed. It's at page 143.
Can you describe it as a right which is a constitutional being on the enactment of the constitution without reference
Absolutely.
to the law being made?
Absolutely. In fact, Shubhankar Dam, whose article I've annexed.
That is one area,
Yes.
we may have a say that it's a real statutory.
Correct. So the note I've handed up, the note I've handed up will show your lordships the entire history of how that concept has been discussed by the courts.
Oh, that's good.
And how it, from 2 judges, it got referred to 3 judges for a decision, after which stray observations in Kuldeep Nair and other judgments were all reconciled. And the position that continues today is that it's resoundingly a constitutional right. But there are two judgments which have put a question mark because they have come back. Two judge judgment. That's at item 10 and item 12. Both of them have, I think in passing, said it's a statutory right.
So it's a three-judge bench.
Two judge benches.
But then the PUCL is 1213.
Said constitutional right.
NSCC page 1.
Correct.
It is said statutory right.
It has said statutory right. So your lordship may consider those three. I put all of them here in this note. I am saying now, one argument with that Shubhankar Dam's article makes, it's published in Public Law. It's annexed in the at page 143 of that compilation I've given your lordships. I've referred to it at page 2. It says that if it were only a statutory right, then if your lordships were to just conceive of a situation when section 62 of the Representation of People Act, which gives the right to vote, if that were repealed, what would happen? Would democracy end in this country? And he expands on it much better than that. So your lordship may just take a look at that article. Justice Chalameshwar's views and Shubhankar Dam's articles, I think, make a very strong argument for why it's very clearly a constitutional right. This question of prisoners, etc., is a reasonable restriction, like you have in fundamental rights. Reasonableness flows through the entire constitution. So even for a constitutional right, this will be a reasonable restriction which would be there. So it's very clearly, in my view, when 326 uses the word entitlement, it's an entitlement to anybody past the age of 18 to say, I have a right to vote. I don't have to look at section 62 for that. I get it from 326. Your lordship will take a look at that note. There's a comparative chart which is at page 4, dealing with all those South Asian constitutions, UK constitution, US constitution, to show how they have filled all those gaps which we have left unfilled. Your lordship may take a look at that. One important thing, which page 4 and 5 of the compilation of the spiral bound.
Okay.
4 and 5 of the spiral bound. I've put the page numbers in the note itself. I'm just drawing the lordship's attention to that. One important thing, yes. One important thing is they all put mandatory figures on the period of the election commissioner. They say 65 years. They give one single figure. Because you have a proviso in our case, there's a problem. If the proviso didn't exist, then compulsorily that man would have to get 6 years. If the proviso didn't exist, please consider that. I mean, we haven't challenged the proviso, none of us, but we should have. We should have to ensure that that independence remains. Now, the only avenue available is, your lordship will see it from our guidelines, is that whatever, when your lordship consider laying guidelines, your lordship may consider that there would be a minimum age which would be in consideration. For the trigger points, point number 6 in my note, trigger points, I've given a bunch of what I believe are the trigger points, one of which your lordships have taken judicial notice of. Statistically, 24% of all members of parliament in this country had criminal cases. 24% in 2004. That number we rose to 30% in 2009. We were proud to say in 2014 that it had become 34%. And now, my lords, it's at an all-time high of 43%. I'm hoping that in 2024, they don't disappoint us. So the problem, trigger point I'll explain is this, that I mentioned, my lords, from 2002 till now, how the Supreme Court stepped in and said, give affidavits, series of judgments, including that last judgment, which I referred to, Ram Babu Singh Thakur. I've annexed that, Ram Babu Singh Thakur, where a timeline was given and it was specifically said, please ensure that all the parties will disclose their antecedents while they're choosing these individuals, etc. If you fail to do so, it will be contempt of the Supreme Court, election commission to file affidavits. Have they filed?
We are on different point. You don't want that.
I'm stitching something up.
That is not the issue before us.
No, I'm sorry.
Happening it.
Your lordship will not. I must explain what I'm trying to tell you. The election commission was asked by your lordships to file reports on it. Did they file reports? No, they didn't.
No, we did.
No, we did. We don't have any reports.
No, I'm sorry. I'll correct my friend.
Yes.
There is a direction by this Honorable Court, Lords, to file a report with a full compliance of the direction. And we've been doing it after every state legislative assembly election. Number one.
I'm saying contempt.
Because the contempt was, there was a, if I may say so, my lords, my friend will agree because he was also operating in that matter. Because the contempt, the court gave a direction. It was only the work which was entrusted to the commission.
You have been doing it.
No, so the initiation of the contempt proceedings.
Just one thing.
Yes. Yes.
A whole lot more helpful.
If I compile it, to one.
Combine
I'll do
all
that.
your notes.
I'll do that. I'll do that, sir.
Otherwise, what will happen is
No, I know.
for separate.
I know. So the spiral bind I'll leave as it is. The additional notes I'll compile.
Notes, put it in
Yes.
one. Then we can
Yes.
see.
Yes. All I was saying is that I still have three minutes more. I'm watching the clock and I'm going to finish. What I was saying on this point was only that the election commission, in my view, had to file a contempt petition here, which they haven't done. I feel there are trigger points and they feel pressure not to do it. There are 3 articles I've referred to. Please just, if your lordship don't mind, in this note, it's just not jot these page numbers down. If your lordship.
By me, you're giving it to us.
It's already there. I just want to
Just put it in one form if you
just
can.
jot down the page numbers. I
Yeah.
just take 2.5 minutes.
Yeah.
The first article, pages 69, 77 to 79,
Yeah.
and 81 to 82
Yeah.
of the compilation. 69, 77 to 79, 81 to 82. The second one, 109. Third one, 117, 119, 120, and 124. These are very informative articles about how gaps in constitutional interpretation are filled up and how we have moved towards where judiciary fills it up. And this is not India. This is Canada, US, UK, everywhere.
That is important.
That's very important. Your lordship may see that. There's also an article by me, which is at page 151, which is how I believe that the judiciary's strength, and this is a 2009 article. It's published in the SEC, but I put it at page 151. Your lordship may see that also. Now, one last thing, last 2 things. In electoral reforms, I've mentioned that there is a particular number of cases where the Supreme Court has stepped in and filled up gaps. Pages 125 to 137 in that spiral bound are the list of all of those where your lordships have repeatedly stepped in. The remedies sought, and I want to emphasize this for a minute. On appointment, I have suggested a procedure adopting the one for the Lokpal. These are possible guidelines I believe your lordships should lay down under 32-142. On the 3 other points that I argued, your lordship put it to them. I'm reminding your lordships that your lordship put it to them. They don't have an answer. They don't have an answer on the question of the protection to both ECs extending. Please make one note that protection to both ECs, reading that proviso in 324(5), they have given no response to it. They're accepting, in my view, the fact that the ECs will have the same protection as the CEC, as far as removal is concerned. In addition, something I just noticed, Section 6 and 8 of that 1991 Act ensures that both on retirement benefits pension as well as on conditions of service, it's the same for all of them. So the only aberration is a possible interpretation which says they don't have the same condition of removal. Independent Secretariat, page 7 of the Government of India's reply, they accept the fact that it is necessary, but they don't go ahead and implement it. Your lordship will consider this along with the consolidated fund drop.
May have,
Now that your lordship are
Your
having
lordships
judgment in this matter,
Yes.
I just wanted to say, my lord, that the doctrine of lis pendens should apply to my interim application also. That same doctrine, meaning I had filed that application, brought to your lordship's notice, pointing out that
Doctrine of mispendence is a abstract thing, not a right to property.
No, I know it's not a right to property. I'm saying that the same principle, meaning that this particular appointment should abide by your lordship's directions in this matter.
may
Her
have,
judgment was served.
may have just,
And Lord, we have handed over that whistleblower notification where the
Lordship,
preamble.
give me just,
We are asking to keep it secret. Lordship, petition 3, we adopt secret. This one.
yeah, I wanted to go about this.
You can see the copy which has been given to us. Keep it sealed in our
Original copy already done.
Original, we have given it back to you.
Your lordship,
We have given it back to you.
the original act,
We have given it back to you.
Lordship, petition 3 will file written submissions, but 132nd point, 324, 4 and 5. Petitioner 3 will 999.
You have never answered.
No, Milos Senior was arguing, but he's not available today. Just that in short point, Milos, and we'll file the written submissions. The point is about 324, 4, 5, and 6 on the vacuum and independence. There was the provision of appointing regional commissioners, which will also constitute part of EC. From 1951, hasn't been appointed. Rather, there has been assumption of role by Chief Electoral Officer, which was not envisaged by Constituent Assembly debates and even the.
Thank you.
Can I just, half a second of your lordship's mind?
Half a second is okay.
Mr. Subhash Gardam is a good friend of mine. I know him fairly well.
Who's your
He written not only this article, written other articles also on several other issues, even issues regarding judicial legislation. I suppose there are some things to be pointed out there. I can always pick up something like this and show it to you. I'll place it on your screen. That's why. As against the infallible arguments on the other side, I suppose I can have one final say. I have not, in the course of my arguments, addressed on the question as to whether a particular model, this or A, B, C, D model, is desirable or not desirable. I don't think the court even went into analyzing which will be the ideal model. No. Number one. Number two, therefore, the question of looking at other examples may not arise at all. Secondly, in each and every one of the cases cited, every one, from Veeraswamy onwards, there is always an immediate trigger point which is a matter of concern. Always. Always. So nothing happened in the abstract. And you were revisiting the question of judicial independence again and again and again. So that is a matter which invites our attention. That's the only thing that can be said. Therefore, there will be something which is left unsaid, something more said. We keep revisiting it. Therefore, can we say there is a gap? So that is a very abstract way of looking at it.
Do you have
that's all.
Do you carry home the impression that you have not placed your best as usual? You have put in you have done yours. We must thank all of you, all members of the bar. I mean, you have assisted us in the best possible way. So we just,
Most grateful.
I was only glad I could assist you a lot.
we said that.
Right.
Assisted.
But these
you've done your karma.
these documents which you are handed over,
Sorry?
those documents you handed over, which will remain with your lordship.
The copies.
That's
Copies will be released. And we will preserve independence to the extent.
I know that.
It may be necessary. We may have to refer to it. That's a different.
That's if it becomes necessary.
If
It becomes necessary. Because I thought your lordships are not getting into that question in it.
How much time for written notes? 3 days.
Your lordships, I thought you not be getting into that question in it.
Do you want to file a written notice about my brother?
Yes, we'll do that. We'll do.
Make a
But as far as this issue is concerned, it may not be necessary for
No, not for this issue. This issue we have understood what the position is. What my brother is asking is whether you want to give a compendious note. And my note
we will do that. I will do that. I will do that.
So then we will say 5 days time.
That's right.
5 days time for all sides to give their brief written note.
On arguments, only on arguments, not beyond what is argued.
What is the argument of you? We don't have to. Within a period, 5 days, not exceeding 6 pages. Whenever we have said 3 pages, what we have found is the font becomes smaller.
We always have.
Also use both sides.
Your lordships.
In fact, Justice Roy rightly pointed out, what happens at times is that what you argue, and when you file your written argument, my lords will find that there are some 6, 7 more grounds.
New points.
So
I mean, limited to what is
has to be restricted to what.
limited to what is
One day,
argued.
by judgment, I said, court,
We should,
what was argued was something
We
different.
found
Different was different.
Limited to what is argued before the court.
It happened before Justice Rastogi.
Yes,
I remember that judgment you delivered. Kerala money.
Fertility of mind.
Argument was quite different. And when I look into the written submissions, they are quite different. I said, but the problem was, I had just since written down immediately after the closure of the submissions. So I have completely fresh to recapitulate what was argued.
Difficulty with the council was that he underestimated my lord's memory is very.
I'm only tempted to say, I'm sorry for saying that, only tempted to say, we're talking about speed. I mean, and somewhere there is something, only if you talk about speed, you comment on that without knowing how exactly it has happened. It is an incomplete comment. And we have cases where, when judgments are not written for 3 months, this honorable court says, then they will become non-est. Therefore, there is always a question of speed, which depends upon the level at which our decisions are being made. Don't therefore These are very comments at a level where I think it's not.
In cricket,
It should not be made.
in cricket, fast bowlers depend on speed, batsmen depend on timing. In this appointment, they depend on both. I'm grateful.
So far as this constitution bench is concerned,
Yes.
so far as the entry of the judges, I am the opening batsman.
Yes. Keep your mind. Yeah. Well, yes, sir. Who is opening? Item 502. In item 502, I have filed one application for framing additional issue. That application may first be taken. But I think there's really nothing. My learned friend has given. Let me.
But I'd like to, first of all, like you to sort of introduce yourself in the sense. Cases are for appearing.
There are 18.
And very beginning.
Yes.
Say, we want to save time.
Yes.
Each one of you will try and tell us what points you will sort of allocate to yourselves. What, because there's no point in repeating.
Lord, we have allocated.
We would request you so that.
Lord, we have divided the points between us. There are 5 councils that are appearing for the.
How many council? 5.
5 is what I think is there. Five for the petitioners. Petitioners.
5 for the petition.
Petitioners who have challenged that.
Okay.
And
There
who
are
are
3. What is the Tamil Nadu Act?
Yes.
Lord, there are 3: Maharashtra, Tamil Nadu, Karnataka. So one is going to be. Lord, I will seek to address on broadly on all
No,
3.
you who are running for?
Lord, we are appearing for different parties, not petitioners.
Please.
Lord, see, Lord,
Give me-
I am appearing, Lord, in 2 petitions where the petitioners challenge the virus of the Tamil Nadu amendment to the PCA.
All right. So you are appearing for the
Yes,
petition.
yes.
What about?
I have.
Siddharth?
So, no, go. But I appear for the petitioners in a writ petition civil number 24 of 2016, Compassion Unlimited Plus PIPA. Then I'm appearing, all 3 statutes are under challenge. Then I appear in PETA, which is People for Ethical Treatment of Animals, writ petition civil 1059, and which relates to the Maharashtra law, and a writ petition civil 1152, which relates to the Karnataka law.
So you have 3 you are appearing.
Lordship.
Animal Welfare Board of India, that's the first petition. That in that the notification was under challenge of 2011. Then after the laws have been amended and presidential assent has been given. So all other petitions are challenging those amendments.
Correct.
So therefore, let them begin first. I will assist my lords in as regard to whatever the Animal Welfare Board.
Then who is appearing for the state of Tamil Nadu?
So I'm appearing for PETA versus Tamil Nadu. So it's a challenge which is laid against the statute.
You are supporting them.
And
I'm appearing for the state of Tamil Nadu, Lord, then along with Mr. Rastogi and Mr. Sibal, Lord, there are 6 petitions filed against Tamil Nadu.
You know, we got the picture.
Yeah. Lord, Tamil Nadu deals with Jellikattu. Tamil Nadu deals with the Jellikattu, whether there is an earlier judgment of
That's
Nagara. Therefore, my Lord,
Yes. So let's, you start.
Yes.
Tamil Nadu can start.
Yes. Lordship, that application first needs to
What
be
is
taken.
that? What is that application?
Yes. That is IA number 17346 of 2020. In the writ petition 1188. This is item number 502.13. Let's just hand over the issues which.
There are 14 cases, isn't there?
Yes, there are allowed see.
There's one by court motion, RS, the last case, Ajay Rastogi